today's event, my Lord, former Dean of the Faculty of Law of this great university, also the former head of GIMPA, head of department for the legal unit of this great university, my own respected colleague at the law school, colleague member of parliament, members of the high table, my dear wife who is with me this afternoon, Mrs. Markin, my dear law students who have put together this program. First, let me thank you for the invitation to be part of today's event. I come here with a lot of nostalgic feeling, having studied at St. Augustine's and having spent 2 years on this very campus studying BCom, and later had to change to BMS, and I think struggling through that, I had to leave for the law school. Because an art student who now changed to do a business program, it was quite challenging. My path was in law, so I finally found my way to study the profession I so cherished, and I have no regrets where I am today. Before I proceed on the topic of the day, let me draw your attention as students to the challenges ahead of you in the career you have chosen for the rest of your lives. The practice of law is not as straightforward as you think it may be. The law you read is not the law in practice. And it is important for you to remember that since the days of the decomposed snail in that ginger beer, the law has taken various forms and shapes, and it doesn't take timorous souls to make changes in society through the law. So brace yourselves and get ready, and don't just read the law and take pride in the certificate, but take pride in your practice. There will be disappointments along the way, and as a Mason will tell you, upon being initiated into Freemason, you see the black and white tiles, and all that it tells you is that there are difficulties and dangers. In all of these, you rely on your God. The good times and in bad. I remember the time I took the oath in the Catholic Church with my wife, in good time and in bad. So remember that. And that is what the practice will be. You will meet judges who will disappoint you. You will meet judges who would intimidate you. But in all of these, take it as a learning curve. You will meet colleague lawyers who would intimidate you. But don't give up. Practice at the Supreme Court is to test your strength. Don't be the lawyer whose practice will end at the circuit court. There are a lot of lawyers in this country who will not take up a case even up to the High Court. And at the Court of Appeal, they would run away. As for the Supreme Court, they wouldn't even dare. Tell yourself that your practice will end at the Supreme Court and you challenge the law. And let the 9 judges be putting questions across. Stand your feet. Get disappointed. Come back home, prepare, and go back again. I recall my respected colleague Fachi and I, on this your university election matters of injustice, I took a case up. We battled at the High Court, I lost it. We battled at the Court of Appeal. And I said, we'll end this matter at the Supreme Court. We battled it there. The rest is history. But let me take this opportunity also to commend highly justices of the Supreme Court who have made me a better person and a better barrister at law. Perhaps initially I misunderstood their approach, but upon a deeper reflection, I think they've made me a better person. Finding Justice Gbadegbe at the Supreme Court, a man of procedure who would intimidate you, and even if you are announcing yourself and you are not careful, he would get you off your feet. I later realized that he was preparing me for a better day in my career. My Lord Edinura, who has retired, would virtually intimidate you and you would see a literal shouting. But she was making me a better person. And my Lord Doche, the calm godfather, who would have a nice way of encouraging you to be on your feet. That was his approach. The Chief Justice, Georgina Wood, will have a calm way of correcting you and have a calm way of urging you to withdraw and come back later. There were some practitioners, as intimidating as they were, they contributed to my career and the career of others. Yoni Kolendi, as he then was, never made me give up. He would always tell me outside of the court, Alex, don't give up. Go back, even when you lose the case. Thaddeus Sori would intimidate you all the way in the courtroom. But outside of the courtroom, he would urge you to keep on with your career. I'm eternally grateful to them. My own law professor, Ace Ankuma, I once had a battle with him at the High Court where he was representing a Standard Chartered Bank. And he had this to say to me, Alex, don't feel intimidated. I taught you all right, but be bold and let's prepare for the motion. That day was my day against my professor. He congratulated me and he still inspires me. This is the way ahead of you. Don't begrudge anybody. There are gossips at the bar. There are things to be said to intimidate you. But this is a profession you have chosen, and be prepared for it. Else you make it a useless venture. My Lord, let me now proceed with the topic of the day. But before I do so, let me also bring to the fore a period of disappointment when a faculty head of this institution had willingly called me, wanting me to join the faculty because he felt I could make a meaningful impact. But quite surprisingly, I'm sure because of my battles with the University of Education, suddenly chickened out, so I never had the opportunity to teach at your faculty. I found it very shameful, but here I am. I was wondering why this invitation to be part of this program. I'm happy the invitation was never recalled, but I'm finally here. I'm ever ready to add my contribution to your career. It is required of me to examine through the lenses of a practitioner the theme for today's program, Judicial Independence in Ghana, a balance sheet. The theme for this conference is apt and timeless because it comes at a time of heightened public discussions over unsubstantiated allegations that the country's judiciary has lost or is losing its independence. So, judicial independence, a definition. My Lord, gentlemen and ladies and students, it is trite learning that the fundamental role of the judiciary is to uphold the rule of law. And here, may I rely on the respected English jurist, Tom Bingham, who asserted that the rule of law is enforced where, quote, all persons and authorities within the state, whether public or private, are bound by and entitled to the benefits of laws publicly and prospectively promulgated and publicly administered in the courts. In practice, the judiciary upholds the rule of law by providing fair and impartial resolution of dispute between parties in line with statute or case law in force. To do this, the judiciary must not only profess independence, but must be seen by all keen observers to be genuinely independent. The term judicial independence, therefore, can be loosely defined as the ability of judges to function independently from outside influences that may corrupt or curtail their ability to administer justice fairly. In other words, the notion requires that judges must be free to exercise their judicial authority without interference from litigants, the states, the media, or influential people in society or other entities. Thus, judicial independence is considered a foundational pillar for mounting and maintaining judicial integrity and the rule of law itself. Indeed, the framers of the 1992 Constitution must have understood this fact. Indeed, the framers of this 1992 Constitution have explained, while giving authority to the President of the Republic of Ghana to appoint certain categories of persons who serve in our judiciary, also cast around the judiciary a powerful veil of independence to shield it from explicit or crafty acts of the appointer. Increasingly, however, the judiciary is coming under unjust fire merely because vacancies have occurred in crucial courts in recent years. And the dutiful President of the Republic has had the discharge that this sacred obligation imposed by the Constitution on him to make appointment to fill those vacancies. Those appointments coincided with subsequent judicial decisions against some plaintiffs of a particular political color. And so, critics have dangerously weaponized the appointment of judicial officers in a way as to mislead unsuspecting citizens into believing that judges do the bidding of the president who appoints them. This is a dangerous trend that must be discouraged to protect the health of our democracy. While there is a case to be made for constitutional reforms to the grant of bail to suspects in cases like murder, treason, rape, etc. In its decision, the Apex Court held that the Section 96(7) of the Criminal Code and Other Offences Act violated, among other things, the right to personal liberty and Article 14 of the 1992 Constitution. Although the outcome of Martin Kpegu No. 2 went against the weight of arguments put forward by the states, no justice was summarily removed from office or threatened with any sanctions. Thus, by its decision in Martin Kpegu No. 2, the Supreme Court not only upheld the rule of law and judicial independence, but also that it used powers under the 1992 Constitution to face an unjust and unconstitutional law. The court destroyed a dangerous statutory arsenal, and states had persistently used the abuse of rights of citizens. I do not doubt that this level of judicial boldness and diligence has remained with us till today. Now let me proceed with my own experiences in respect of judicial independence in our country. Since I was called to the bar to practice before the court of Ghana, I have keenly observed within intimate proximity the concept of judicial independence at play. On one hand, I have followed proceedings in many landmark cases decided by the courts. On the other hand, I have actively participated in courtroom proceedings that have given birth to some of the most authoritative decisions in our courts, and here a few examples should suffice. For instance, I saw how the Supreme Court in its wisdom rejected the election petition filed by the then candidate, Nana Addo Dankwa Akufo-Addo, and two others, after the disputed election of John Dramani Mahama as president in 2012. I also witnessed how the learned justices of the Apex Court of our land, again, in their wisdom, dismissed a similar petition filed by former President John Mahama, challenging the re-election of Nana Addo Dankwa Akufo-Addo after the 2020 elections. While scholarly and public sentiment concerning these two decisions still vary greatly and often clash, I firmly believe that the respected justices showed up for work when our nascent democracy needed them most. They did not crack when some threatened fire and brimstone should they lose in court. They stood up as human and took decisions which may not be perfect, but nonetheless played a massive part in protecting and defending our democracy when critical pillars of its superstructure felt threatened by post-election rage. In 2015, I observed judicial independence at play again. It was a year for new metropolitan, municipal, district, and local assembly elections. As it turned out, I served as lead lawyer for the plaintiff in Benjamin Mensah versus Chairman of Electoral Commission and another. Mr. Mensah, a fisherman in Winneba, had filed a suit at the Supreme Court, having felt that the Electoral Commission had unjustly denied him the right to contest in elections in Winneba, despite meeting all conditions to vie. The crux of his case was that the constitutional instrument CI-85, which was a form of the legislative foundation of the post, had not matured, let alone become the law within Article 51 of the 1992 Constitution. The court, speaking through Justice Atukuba, held, quotes, "We are driven to hope, and we so hope that at the time the upcoming district level election processes were set afoot, there was no legislation covering sale. CI-85 can have no retrospective effect. Accordingly, we declare that it is unconstitutional to proceed with the impending district level elections, since sale cannot be warranted having regard to Article 45 and 51 of the 1992 Constitution, which mandatorily require the Electoral Commission to hold elections and the regulations made by them under the constitutional instruments. While that initial efforts, unfortunately, led to the cancellation of that year's district local assembly elections across the entire country and caused the state to lose scarce resources, it did not have, which they did not have. The fact is, the rule of law had prevailed. Our venerable justices of the Supreme Court, in fighting against the Electoral Commission, robustly defended the right of Mr. Mensah, a law-abiding citizen, who put himself up for election to serve the good people of his community. Most importantly, by their bold and unprecedented decision, the learned justices of the Supreme Court upheld the letter and the spirit of the Constitution in a manner that guaranteed and furthered the interests of the rule of law by protecting a relatively powerless citizen against the intransigence of a powerful state institution like the Electoral Commission. The decision in the Mensah did not leave the justices losing their jobs. This is a marked departure from the days when decisions against the state caused the removal of judges from office. But it must again be emphasized that in Dr. Mark Esebe versus ECG and 3 others, as well as Richard Sky versus Attorney General and Ghana Bar Association versus Attorney General as consolidated, something surprisingly happened. Much as I disagree with the position taken by the court, it is what it is, and that is the beauty of our democracy when it comes to our rule of law. For the avoidance of that, in the Esebe case, we had state institutions providing a guarantee to support a transaction by ECG, which involved a private sector actor. The contention of Dr. Esebe was to the effect that, to the extent that Ghana National Petroleum Corporation was providing a collateral, but that was the decision of the court. Again, in the Registrar case, a clear case has been made where the president had made an appointment on the advice of the Judicial Council. The contention of the GBA and my respected colleague, Richard Sky, who is a member of the English Bar, was to the fact that the issue of advice must be construed in a proper context. in the order upon which the advice has been given. And here, if you may recall, the Judicial Council had given an advice in a certain order of merit. Here again, we were disappointed when the hour of decision came. Registry arguments were not considered at all. The GBA arguments were discussed in detail, but the court was inconclusive. I challenge all of you to go and read the case. The end of it, the court said, mutatis, the case is dismissed. And we're all wondering what the court meant. My Lord, senior members of the bar, members of the faculty, students, may I conclude by submitting that based on the evidence I've heard, I dare say that on the whole, the judiciary in Ghana has demonstrated that our courts have come of age. It has left the dark shadows of its ignorance past and appears resolutely committed to defending all citizens' constitutionally guaranteed rights and freedoms. Indeed, despite the view above, there is still room for improvement. Nonetheless, it is a fallacy for anyone, no matter how distinguished, to suggest that the judiciary in Ghana still bends to the will of those who belong to the executive arm of government. Indeed, let me state without any fear of contradiction that it is fair and democratic for citizens to criticize the work of our justices constructively. We saw this in the constructive criticisms that followed the judiciary bribery scandal in 2015, and how the institutions of state responded swiftly by punishing all the justices and the judicial officers who were found culpable. However, there is everything diabolic about barefaced attacks that in and of themselves seek to intimidate our justices and bend them to the will of those sections of the public and the political class who believe that, willingly, they are entitled to win every case, no matter how weighted the evidence supporting their claims in court. Such attacks undermine public confidence in our judiciary and go a long way to encourage unsuspecting citizens to take the law into their own hands in a way that poses a potent threat to our national security. I conclude, therefore, by saying that we cannot and must not allow the self-interest of a tiny few in and outside of this country to sink the carefully crafted justice and adjudication system that has held our motherland together. We must resist the invitation to regard our justices as pawns of the executive. Instead, let us mount every powerful pressure we can command as citizens and leaders on those demonizing the judiciary to abandon their ignoble quests. These are desperate schemes to put fear in our justices and erode the integrity of the entire judicial system. Our individual and collective peace and security depend on upholding the integrity of our judiciary. And I must, before bringing the curtains down on this, commend highly my respected colleague in Parliament, Honorable Sosu, for his courage and his chosen part in human rights advocacy. The road may be rough. I recall said the DNI director was inviting me for discussion. My only crime was that the financial law, which Yoko and FIC were enforcing at the time, had put fear in lawyers in the country, and it appeared that Afenyo-Markin and some few others were the only ones challenging the law. So the fear of God had been put in me. But today, I stand up with pride that all those decisions that are misinterpretations, we fought all the way to the Supreme Court, have become leading authorities that are shaping the jurisprudence of our country. So you may be walking through the valley of the shadow of death. Fear not. The path you walk, you've not been there alone. You are not the first to walk that path. I was there, and I'm still there. Don't give up. Many others will take inspiration from your industry, but take it easy. Be calm. You will get there. Who knows? One day you become the attorney general. And students, I leave you with this. Don't take courtroom exchanges personally. Today, one of my personal lawyers doing my cases for me is someone I never thought would ever be a friend. Because we have serious battle. Several of them at the High Court, at the Court of Appeal, and at the Supreme Court. He would win, I would lose, he would win. We'll get split decisions, we'll go for review, and we never saw eye to eye. Until one day, we met at the cafeteria and broke bread. I never thought lawyer Atacherius would today be handling my briefs. So I tell you that when the battle is on, don't take it personally. There's the beauty of the law. Don't attack your colleague merely because he disagrees with you or he won against you. One day that person will become your own lawyer and may be writing your will for you. Okay? And in school, learn to tolerate. That's the beauty of the path you have chosen. I thank you for your kind audience. I thank you for your patience. I thank you for listening to me. May God bless our homeland Ghana and make this country great and strong. God bless us all.